Welcome, everyone. I'm Jared Bartle. I'm one of the consultants here at the Bridge of Hope Innocence Initiative. I'd like to start off the webinar today by acknowledging the traditional owners of the land that both myself and Michelle are broadcasting from today, the Wurundjeri people of the Kulin Nation, and I pay my respects to elders, both past and present. For those of you who don't know about the Bridge of Hope Innocence Initiative, or BOHII as we call it, it is a joint venture between RMIT University and the Bridge of Hope Foundation. Our aim is to investigate claims of wrongful conviction and to prevent future miscarriages of justice through advocacy and reform. And today is the first of kind of a webinar series that we'd like to get going looking at innocence issues. And the one today relates to a position paper that we've put out in relation to an Australian CCRC, which Michelle is going to speak about. Just one quick little housekeeping note before I pass to Michelle. We will be doing questions at the end today. You should, hopefully on your screen, see a little Q&A option up in the top right. You can click on there to submit your questions. If you don't have that option, I'll also be checking the chat. So if you can ask in the chat if you don't have that little question and answer option available. But at this point, I will pass over to the director of BOHII, Associate Professor Michele Ruyters, to speak on the topic of why a criminal case review commission may not be the solution. Pass to you, Michelle.
Thanks, Jared. So welcome everyone, and thanks for giving up your lunch times. I should point out that I am working from home today with the usual problems of tradesman, incontinent and senile dog waiting by, but I think I'll get through it. The reason why we're having this seminar or this webinar is because there's been obviously a lot of discussion recently about the need for an Australian criminal case review commission, and we wanted to raise perhaps a different perspective. So I'll just start with a little bit more about who we are and what we do. As Jared pointed out, we are a campus workplace at RMIT, and we're set up for students to investigate wrongful conviction claims. We're one of 5 university projects in Australia, and we're the 3rd oldest. The oldest is the Griffith project, which I think has been around for about 20 years. And Edith Cowan project, I think probably around about 14 or 15. So when we've been running since 2014. There are also projects at Sydney University and Newcastle. And other projects are being established, I believe, at the moment. So we're based in a criminology discipline, so we're very much fact-based. It's all about the facts. And because we're set up as a campus workplace, we're both teaching and practice focused. We take around 30 interns a year who do 50-day internships with us, and they do it for credit in their degrees. So 50 days times 30, gives you quite high volume hours, being able to look at materials. We're a team of 9, including 3 sessional staff. That doesn't mean, unfortunately, that we're spending all our time on the cases and with the project. But we divide the load up with our other university-based work. And we direct casework, we provide supervision, we liaise with prisons, lawyers, oversee student welfare, etc. Just want to talk about our ambit. Because we are a teaching organisation, principally, we have safety limits on the kind of content that we will expose our students to. Oddly enough, it doesn't exclude murder, sexual assault. And but we certainly exclude offences involving, for example, child pornography, and we don't take cases that are likely to put either our students or our staff at risk. We have other practical limitations in that we have a policy of not talking to victims, not communicating with victims or their families, because we just don't want to re-traumatise people and, for the purposes of the investigation. And obviously that can have a bit of a slowdown effect. We have a three-stage process, which is, and I've got at the top that we're very much a ground-up investigation, and I'll talk about that a bit more on the next slide. The three stages can merge depending on a particular case, and sometimes the injustice is so palpably obvious, from the moment we have a look at the materials, that we just accept the investigation and move on. The ambit phase is really more about, just fact checking that these cases do meet our criterion. I should point out that we're not limited to cases that have actually been on appeal. A number of people just simply can't afford the appeal process or have been denied the appeal opportunity. But we're, very happy to work with law firms and in assisting that process as well. So looking at our investigation process, what we do, because we are very fact-based, we aim to go right back to the very beginning. And so the what's missing phase is the longest and most intensive part of our process. We spend a lot of time developing, and I've got students in the group who are very familiar, watching today, very familiar with this process, developing very detailed chronologies. We spend a lot of time cross-checking statements, testimony, exhibits, just looking to see what didn't make it to trial, and particularly what wasn't disclosed. We look at, what perhaps might have been overlooked by the police. For example, we've been contacted by people who were at the crime scene, had information to share, but just were never contacted by the police. So that can be incredibly valuable. Looking at what might have been collected at the crime scene, but never disclosed. An example of that is fingerprint evidence collected at the crime scene, but neither the sample, the analysis, or the fact that the prints were taken, being disclosed to the defence. Then looking at what would have been collected, but at the crime scene, but was perhaps overlooked, or maybe a deliberate decision was made to leave that thing behind. An example I've got is in one of our cases, we've got, I guess would have to be called a very inadequate police search, where the potential murder weapons were very conveniently staged, almost pointing directly at the defendant, literally. But other and more likely suspects weren't even searched while they were at the scene. So the police just accepted the most immediately obvious story there. And then we also aim to reconstruct the materials if necessary. And this is also an enormous part of the process, because most of you be aware that prisoners can't keep all of their materials. They don't have access to all of their materials when they're in prison. And they might not even know where to find them. They're distributed to family, bits and pieces go everywhere. Lawyers don't hang on to copies, forever. So it's really difficult to get some materials. Exhibits are returned to key witnesses, and evidence can be in storage anywhere across the state. So that's a bit of a problem as well. So I'm just going to give you an overview of the kinds of cases and go through some of the issues and the practical and functional problems that we've experienced. I will get to the CCRC issue, but I want to really spend some time looking on our experiences, because it's our experiences that have informed our position on the CCRC. At the moment, we've got 167 cases, and these are at different stages in our process, and these don't include initial contacts where, for example, someone has asked for our help, but they haven't followed up, and there are quite a few of those. We rotate the cases around that the students work on. But this can depend on the stage with which the case is. If something is kind of live and we've got a really useful avenue of inquiry, then we might keep working on that on successive semesters, and the staff provide that continuity between semesters and work on the cases. The cases are mainly what you see: child sexual assault, homicide, sexual assault. Child sex offences are probably 20% of the cases, but probably most of our inquiries. And I think a lot of that has to do with self-referrals within the prison system. As an indication, though, we've only accepted 2 of the child sex offence cases for like a substantial investigation. And that's mainly because typically there's just no way of independently proving or disproving any of the disputed facts. Probably more significantly, because a lot of innocence projects overseas are associated with DNA related overturned convictions. Very few of our cases involve DNA at all, and we've only got 1 case which is hinging on a DNA retesting, and that hopefully will happen very soon. And similarly, very few even involving or relying on forensic evidence. Forensic evidence is often kind of value neutral. It's collected by police, but it's not indicative of the outcome in the case. And the most significant factor that we see is the way that witness testimony is given and how that's received. I'm going to talk just a little about circumstantial evidence on the next one. Most of our cases are circumstantial evidence cases, and in many of those, there's evidence of motive and a prosecution narrative, but not much of anything else. So as I said, there might be neutral or a neutral forensic link, no links to, no independent evidence establishing the person was even necessarily there. Very much about motive. One feature that's occurred far more than we thought it might is that there's appears to be a clear pivot point when a far more logical alternate suspect suddenly becomes the star witness. And that's often despite histories of unreliability and dishonesty. And that's, as I said, it's appeared far more than we anticipated. We've also got a number of false confession cases and cases based on lawful inducements through, for example, the Mr. Big technique, and lots of difficulties with the historical cases that occurred before the requirements for recorded police interviews. So they're very, very difficult. A lot of the issues around the alternate suspect becoming witness often seems to be because of tunnel vision by police. Anyone who's familiar with this area would exhibit no surprise. But it's also very common in evidence being overlooked. And, as I said, witnesses, I guess, being bargained away, or key suspects being bargained away because they suddenly become key witnesses. The last one I'm looking at is, and I really want to highlight this because this is probably the most prevalent factor, and it was so surprising, is the number of times we could see from our very advantaged position of being able to spend a lot of time on the cases, many opportunities for lost or untaken defence opportunities to either call or cross-examine witnesses on points which later appeared to be really critical. And in many of those cases, the need to call or cross-examine the witness probably wasn't, or most likely wasn't apparent because some of the facts were incredibly complex, as well as complex timelines. As an example, one of the cases that we had, a key witness claimed to be absent and asleep when a murder occurred. And this appeared to be well supported by the evidence of 4 other witnesses who were there at the time. But when we cross-checked the evidence, the statements and the evidence of the all 5 witnesses against independent evidence, which included 2 lots of CCTV, which could pinpoint time and location, as well as against each other, it was really very clear that the witness was not just very present and awake, but a logical alternate suspect, and that opportunity has gone. But those facts and the evidence was so complex, it took us 2 days just to kind of piece this together because everything happened in a very short period of time. And in this case, all the other 4 witnesses have died, making it very difficult to progress. Some other issues that I really want to emphasise here, and particularly in the context of a CCRC discussion. Our experience is that convicted people will focus on the issues that are important to them, but are either just not helpful or completely irrelevant to pointing to any kind of evidence that's going to support their claim. Most will focus on procedural issues that they think went wrong, or the failure of the judge, the prosecutor, their own lawyers in doing something. And even in cases where we can see that there are strong factors and strong factual considerations indicating that this person is innocent, they really struggle when we say, well, can you give us some idea about how we can actually prove this thing or disprove this thing? It's really hard for them to think laterally about their own case when they're in their own minds. They weren't there. It wasn't physically possible for them to have done the thing because they're innocent. So it's very difficult for them to wrap their minds around locating that kind of information. They also really struggle completing applications and working out what's important to tell us. We realised really early that we were missing vital and vital information, but most importantly, overlooking genuine wrongful convictions, because on the surface, at least, it appeared that they didn't meet our application screening process. And, we realised that we needed to walk and talk them through their applications to get the information we needed so that we can make a decision. So speaking to the convicted person really early in the process is critical. Every single time we have spoken to someone or visited the person, it's absolutely changed our views 180 degrees. And even it's been in situations where the person has eventually admitted to us in a conversation, well, actually, they're just after a reduced sentence, or they admit doing it, but they didn't mean it. And that just makes it so much easier to deal with the cases as a reject and then moved on without any wasted time. So our caution is in assuming that wrongfully convicted people can do this, can clearly identify the evidence that's going to establish their innocence, is unrealistic and is going to lead to genuine wrongful convictions being overlooked. Just going to move on to some, and I'll try to move through these pretty quickly, some of the practical and functional problems that we've observed. And some of these I've talked about already. And, like the difficulties of reconstructing case files, working out whether or not exhibits still exist, can they be obtained? We spend a lot of time trying to locate witnesses across Australia to speak to them. They disappear. Some of them have died because of the age of the case. Or they were homeless to begin with and still are. FOI requests, I imagine I'm probably preaching to the converted here, particularly if the police are really tough, and particularly in older cases where they do have a good argument to say, look, we don't want to waste our time digging this out, locating it, working out whether or not we can give it to you, or working out what needs to be held back. And this is a huge problem in trying to obtain particularly undisclosed recordings, particularly when we're talking about hundreds and thousands of hours of recordings that weren't disclosed, because the police will claim, look, we can't make that decision until we've listened to all of those recordings and individually, and we don't have the resources to do that, so you can't have any support. You can't have that information. Other functional problems are, and this is one I'm kind of describing it as the progressive dropping of witnesses from crime scene to trial. Obviously, that's something that occurs in the natural course of things because, as issues are refined in the case moving ahead, witnesses, of course, drop off from the police investigation, pre-trial and trial processes. But the opportunities are lost to, recoup some of that information to investigate, let alone do anything about it post-conviction. And, as example, we've been contacted by witnesses who were briefly questioned by police and never spoken to again, who've come forward with, for us, certainly really interesting and useful information that's progressed our cases, and wondered why the police decided not to pursue that. And I also include in that kind of the inclusionary and exclusionary decision making that police make at the crime scenes about who's a witness, who's useful, who they're going to talk to, because they very rarely walk that back. This issue of funneled evidence, it's probably a bit of a contested term in my team. I'm using it to describe the situation, also very valid, where one witness will testify on behalf of several. So, for example, one crime scene officer will give evidence on behalf of, 6 or 7, and one emergency service worker will do the same for the group that attended. That makes perfect sense from an economy perspective, but once again, you're losing opportunities to cross-check information across each, look for, obviously cross-examine on any of the discrepancies between them. But this is really, really common. And yeah, so the funneling effect means that there's no certainty that the crime scene narrative that's presented at trial is the actual crime scene that the police were confronted with. The other issue, well, several issues here, but the third one is kind of I guess a no-brainer. The more time that's lost between the conviction and a review of that conviction means that materials are just kind of lost to the wind, and witnesses, and it's just very difficult to get those back. The fourth issue that I've got here, forensic decision-making in trial, I'm going to talk about this a few times, and I've already spoken about it in the context of unexplored evidence at trial. The general rule is that counsel has a really wide discretion in conducting trials, and parties are bound by their counsel's decisions, even if they're against those their wishes. But this can, I'm just kind of flagging where I'm going later, this can take a fresh evidence appeal completely out of the picture. The last couple, they're kind of related to I guess the same issue. And I just want to preface this by a couple of comments about legal aid. The majority of cases in Australia, criminal cases, are legally aided. And in 2019, Australian Law Council was already warning that the legal funding crisis was at breaking point. So in most cases funded by legal aid, preparation fees are substantially restricted. So, for example, and I haven't got any data, but for example, Victorian legal aid only allows fees for reviewing and listening to specific segments of video and audio recordings, which means that counsel's either listening unpaid to the whole of the recorded material or only consumes the content within, the limits of what they're actually getting paid for. So non-disclosure, once again, surprising no one who's in this space, late disclosure, lack of full disclosure is a massive problem. I don't think we have one case involving recordings where non-disclosure wasn't an issue. We've seen a lot of material that was nominally disclosed, but just not identified. The defence had no opportunity to find that tiny little phrase in a document and note that this was non-disclosure, when they're looking at thousands of pages. So a wrongfully convicted person might not be aware that some evidence was available to them at trial simply because counsel didn't have the paid time to discover the potential non-disclosure, which they might otherwise have corrected. And this, once again, has enormous consequences for fresh evidence appeals. And when I'm talking about partial disclosure, I'm really talking about kind of broad and selective disclosure. So, for example, a description of AV recordings, and that's all, with no details about the number of recordings, the number of total recordings, the numbers of recordings that are actually disclosed, the number of recordings that are actually obtained under the warrant, or sometimes even the existence of the warrant in the first place, which means you've got no hope of working out that there were other recordings there at all. So just some other practical issues that I just want to flag before I move on to the looking at the post-conviction stuff. In many other cases, and then this goes to a lot of what I was talking about people's capacity to understand what was happening in their case, this is even more so when people lack the capacity to understand for what's going on, either on a linguistic or a cognitive basis. Most people are completely bewildered. Most people that we speak to who are not experienced, are completely bewildered by the court experience, and they really struggle with understanding the significance of anything that's happening on a day-to-day basis. And obviously that's particularly difficult if someone has a cognitive impairment or that at a linguistic disadvantage. So in one case that we have, the defendant spoke very little English, minimal. They were provided with two interpreters at the interviews with the police. They didn't understand the first interpreter at all. The first interpreter didn't speak their language, and the second interpreter didn't speak their particular dialect. And despite the need for interpreters at the station, their lawyer didn't engage an interpreter to obtain instructions at any time, and they weren't provided with the right interpreter until the pre-trial proceeding. And in relation to lawyers, often this is, for anyone, it's very difficult because sometimes people can signify that they understand when in fact they clearly do not. So in this case, while this person had copies of their materials, there was no time between her arrest pre-trial for her to read, understand, absorb anything in the police brief, particularly the statements made by key witnesses. And as far as I know, defendants for whom English is a second language don't get translated copies of the case against them. And just in this last one, I just want to point out there are enormous difficulties with simultaneous translation in court. Interpreters are rarely provided with the materials, and they just have to do their best to convey it to the defendant in one sitting. So the defendant, in this rolling kind of way, is expected to have retained everything that was said, that they understand from the interpreter, but having no means of fact-checking the accuracy of anything that was said against the materials because it's in a language that they don't understand. And this is something we've seen in a few cases. The next major point that I just want to point out, and I have spoken about this before, I just mentioned that, alluded to it briefly, really complex trials, and we have many on our books, involve hundreds, if not thousands of hours of covert recordings, from telephone intercepts and listening devices, often in languages other than English. They are usually of a very poor and indistinct quality, and particularly complicated, when it's about, drug activities or other illegal activities, often the use of code words, which could mean many things in other languages. One of the main problems here is that those kinds of recordings are usually translated directly into English rather than being transcribed into the original language and then translated. The voices on the recordings have to be identified and attributed to different speakers, and this is done by people who don't have necessarily expertise or familiarity with the voices, and that's particularly problematic if it's the police. So there's and we've often found that while hundreds of hours of recordings, the actual recordings of conversations might be disclosed, most of them in languages other than English. So there's a clearly significant cost for the police in transcription there. And ultimately, there's always a possibility of finding conversations that haven't been disclosed or haven't been transcribed or haven't been appropriately transcribed and translated, which kind of hold the key to innocence claims because no one has listened to them. So just moving on to where I'm heading with the CCRC. And I am joining, when I'm talking about fresh evidence, I am talking about the use of fresh evidence in the context of first appeal, but primarily in the context of second appeal options. So from our perspective and the cases that we see, any post-conviction review mechanism that relies on the production of fresh evidence is going to exclude most cases of potential wrongful conviction, hands down. And for those who are not familiar, fresh evidence is evidence that wasn't reasonably available at the trial. And the High Court's been really clear that there's no miscarriage of justice just because the accused didn't call evidence that was available to them at the trial, or they should have been, they would reasonably have been expected to be aware of even if it turns out, it seems that there would have been a different verdict. So there are two main problems there, and it relates to the point I was making about decision-making by counsel. As I said, defendants are bound by those decisions, and appellate courts have consistently found that there is no miscarriage of justice in those cases in holding an accused to those tactical decisions made by counsel. So defendants might have had the capacity to read and understand who might not have had the capacity to read and understand these very complex materials, have no chance of then appropriately instructing their lawyers or understanding what is happening in this decision-making process, but there's no going back. And I just want to point out, I'm not talking about misconduct here. I'm just talking about the rational decision-making that would have seemed appropriate and in the best interest of the defendant at the time. But in hindsight, could have been miscalculated, or in most cases, I think misdirected by, for example, significant non-disclosure, which made that impossible. So moving on to the second line of appeals legislation, I've just got the current situation in Australia here. So a recent check has shown that South Australia has had 8 applications since 2013 with 3 successful appeals. Tassie's had 1 application since 2015 with no successes. Victoria's, you can see, 9 applications with 2 successful appeals. Mockbell in 2020 and Roberts last year. And no applications yet for WA because that's just come in. And I'm going to talk about that on the next slide. On one perspective, that looks great because frivolous applications clearly aren't overwhelming the system. From our perspective, though, 5 successful appeals across Australia since 2013 suggest this is a system in crisis and it's unable to deal with the very real problem of wrongful convictions. We have no idea of the likely percentage of wrongful convictions because there's just no way of getting that information. But even at 1% of all convictions in Australia, even if wrongful convictions are 1% of all convictions, that's an extraordinary number. So just looking at those jurisdictional differences, and before I get on to looking at the CCRC, with their second right of appeal, they all rely on fresh and compelling. There are limitations to the kinds of convictions that can be looked at. But where I'm heading next is the new legislation in WA, which is a significant departure. So you can see the new section 35D of the Criminal Appeals Act includes a failure to tender evidence due to the incompetence or negligence of a defence lawyer. Now, that's not covering the situation that I was talking about before, where the failure to tender wasn't about incompetence or wasn't about negligence or misconduct, but it was about other factors. But it's certainly a step in the right direction. And the second departure is that the court must allow an appeal based on new and compelling evidence if satisfied on balance of probabilities that, in the light of all the evidence establishes innocence. And I won't talk more about this, but once there's a process, I think the expectation with this legislation is that the application to leave to appeal will be dealt with on the appeal in most cases. And then once an appeal has commenced, there are kind of limitations on how this new and compelling will operate. So the court must not give leave to appeal unless they're satisfied there's a ground that identifies new and compelling evidence that should be considered on appeal in the interest of justice, and that the ground has a reasonable prospect of success. Okay, so I know I'm moving on a little bit quickly, but I just wanted to point out some of the issues with the fresh evidence requirements, particularly related to the second right of appeal. And then before moving on to the CCRC, just pointing out, I guess, some of our learnings that I've already talked about that I think are absolutely fundamental for any review body, that you cannot have a situation where applications are, or decisions to reject or accept applications are made on the basis of what are called desk assessments. So, and that means just looking on face value on the application, look at the information there and making a decision to reject or not. And as I've already said, people they cannot fill these out effectively for our purposes. We'd be really concerned about any threshold review process that relied on a desk assessment, which is a process adopted by the UK CCRC, because these are so likely to overlook genuine wrongful convictions, and they significantly disadvantage anyone from a vulnerable background, as I've pointed out. And the last one is any effective review process. I don't understand how any application can be dealt with without this. It has to include a conversation with a convicted person and get their perspective. And I've just found it extraordinary that cases can be dealt with without this happening. So just some other considerations in looking at what a potential review body must do. A review body is not necessarily an investigative body. So, and that means if they're a review, they're interested in probably other factors than getting to the truth or the facts of what actually occurred. So they have to have that investigative function. And conviction review bodies, and this is one of the criticisms I will raise when looking at the UK CCRC, is that they're not necessarily concerned about innocence. They're more concerned about reviewing the safety of convictions than establishing factual innocence. So finally, I'm moving on to the point of why I'm having this webinar. Just a quick snapshot on the CCRCs. The North Carolina one is strictly not a CCRC in that kind of model, but it is doing the same things. And I'll just move on to give you some idea of the process to date. Clearly, the UK CCRC has dealt with the most applications, with just getting my notes so I get the figures right. Over 30,000 applications, 819 referrals, and with, you know, I guess on face value, a very good 557 successful appeals. And you can see the other figures there in front of you. I want to focus primarily on the UK CCRC. So I'll just go on to the next slide. And looking at the criticisms, and these are well known, these have been ongoing for the last probably 10 or 15 years, and they've been well published criticisms. A lot of these have to do with the limitation that the threshold for referral is tied to the appeal criteria. So it can only refer cases it can only refer cases if it considers that there's a real possibility the conviction wouldn't be upheld by the Court of Appeal. So it's not likely to refer cases unless it finds a substantial legal error or fresh evidence. While it looks as if they've had a large number of referrals, their success rate on appeal is around 68%, but it's actually only referring around 2.7% of the applications that it receives. Another factor is, as I pointed out on the previous slide, that the CCRC doesn't reinvestigate cases. They look at the claims and the evidence provided by the applicants. And from what I understand, it's not common for them to visit prisoners to get their perspectives in person. There were other concerns that the people who are doing the reviews and the people who are doing the investigations aren't sufficiently trained in those activities. So if the CCRC, and it does, conducts desk reviews, doesn't visit the person, and doesn't necessarily have sufficient training so that people can maybe detect issues that are inconsistent in the DES applications. This is really putting a lot of pressure on the applicants to the CCRC in a situation of needing effectively to carry out their own investigations and making sure it's front and centre so their application gets looked at. So I will move on to looking at an Australian CCRC. So our thinking is that decision making, any Australian CCRC is more than likely to be tied to state appeal criteria. And that's because of concerns that any independent powers to overturn a conviction could encroach on judicial independence. And it could also create a really inequitable post-conviction review process with people who are pursuing traditional appeals needing to satisfy a much higher threshold. So for those reasons, we think it is most likely for that to be the case. And then allied to that are our concerns relating to fresh evidence and the difficulties that many people who have probably factual provable situations in cases that they are innocent can't get them in front of an appeal court. Another issue is that investigating wrongful conviction claims is very resource intensive, and the operations of the UK CCRC have been significantly impacted by funding cuts. And that's obviously had a run-on effect to how they are training and how they're reviewing, etc. So it's really difficult to estimate an appropriate budget for an Australian CCRC because how can we predict like the volume and the complexity of the cases that are going to come forward? But I think it's really unlikely that an Australian CCRC is ever going to have adequate funding to provide the resources and the hours that are needed to fully investigate a case. And I guess probably our last point there is, along with the second right of appeal provisions, while these are welcome and while the CCRC of course would be welcome because all progress is welcome and every overturned wrongful conviction has to be celebrated, but these really do risk being a band-aid solution to a massive problem. And I've said, really do risk excluding the majority of wrongful convictions who don't meet these criteria. And finally, I've lost my way, but I'm just moving on to our position. And so rather than implementing a CCRC or lobbying for a CCRC now, we think that the amendments, the progression in WA is a really great place to start. So let's look for how we can broaden scope for new evidence appeals in those situations and expanding definitions of fresh evidence in a similar way. Inadequacies in police and prosecutorial disclosure, even in states that have certificate processes, can be addressed potentially by having random independent auditing of those certificates and requirements for the complete and itemised details of disclosed materials. In jurisdictions overseas, some jurisdictions, they get the whole lot. Like there's no need for this, for disclosure in that context, they get everything. We also, because of the problems of data retention materials, lost materials, having a mandatory centralised digital storage system to assist in post-conviction review is really a no-brainer. And having storage requirements mandated at the completion of every prosecution, including the storage of all documents and recordings, also I think is a no-brainer because there's no escaping the context and the reality of a wrongful conviction. They are happening. Certainly we agree with any call for a national review into the reliability of forensic evidence, but as I've said, that's not a big factor for us. Obviously, we'd like funding for the projects. I should point out that our project is completely unfunded. We get no support other than some philanthropic funding. Also, I have got increased legal assistance funding, but that's kind of the great wish for everyone, that legal aid would increase. But I'd certainly like to see increased funding for police to provide, to be able to engage appropriate experts in the transcription of covert recordings. They have to factor in the cost of interpreters in their budgets, as does any government organisation using an interpreter. And I'm not aware whether or not this is a factor in decisions to, engage interpreters at police interview situations, and hopefully it's not. But certainly more funding there, so that police can do the job that they need to comprehensively. And our last point, and this is where I'm kind of leave it, and I've spoken about this before, we need to prioritise research into the kinds of risk factors for miscarriage of justice in Australia, because they are going to be individual to this country. We can say that we experience the same problems of witness misidentification, tunnel vision, etc., as other countries, but we really can't know anything about the prevalence of that or whether or not there are individual idiosyncratic factors to Australia itself. And particularly in the context of sort of situations experienced by Aboriginal, Torres Strait Islander people and other vulnerable groups that are grossly overrepresented in the criminal justice system. And I'm just going to conclude by saying that, I'll just kind of sum up, I guess, by saying that discussions about post-conviction review bodies like a CCRC is premature when we don't know enough about the state of play, as I've just pointed out. So until we know more about the kinds of errors and put in preventative measures to stop miscarriage of justice in the future, which can potentially indicate where the risk factors are, we really don't know what is the best mechanism for addressing the extent to which these can be detected or remedied. So I'm going to leave it there because I've talked way too much.
Thank you, Michele. I've got a couple of questions, but I was just going to start off with a broad one that I know has kind of come up since we announced this webinar, which is why not have a CCRC? So, pointing out that there are inadequacies if it was implemented in terms of the UK, Postphobic, there seems to be this kind of movement at the moment. Why not pursue this extra option regardless, realizing that it's going to be imperfect? How would you respond to that?
Because I don't think we'll do enough. As I said, I don't think there's a potentially large number of people who are genuinely wrongfully convicted. And if a CCRC process is tied to narrow appeal criteria, and we're looking at the numbers that are creeping through the second right of appeal process, I don't have any confidence that kind of process is going to address the very substantial problem of wrongful conviction. Hooray for all the cases that do get through, but my concern is for the cases that don't meet those criteria. And I appreciate that a lot of that is about how a CCRC is set up, but I really can't see any other way of it having it tied to those appeal criteria.
On that point, there was a question here about, why not we have a CCRC that isn't tied to an appeal criteria? I know you addressed that briefly in the slide, but why is your assumption that it's likely to be tied to that fresh evidence criteria?
Well, I don't know that's necessarily likely. I think there would be reservations because of encroaching on judicial independence. I think from an equity perspective, then we are setting up two pathways to post-conviction review, and one is going to be potentially easier path than the other. So people who are pursuing wrongful convictions through a traditional appeal process, as is their right, are potentially facing tougher criteria than they might going through and don't have the same resources as someone who is pursuing post-conviction review to a CCRC. So a CCRC can potentially exacerbate inequalities.
Yeah. There's a couple of questions here just in terms of, I guess, concerns that innocence initiatives or people working in this space might be seen to be divided in terms of their goals. There's There's obviously some groups that are really in favour of a CCRC. I guess, how would you respond to that kind of division perspective?
Well, I guess the 5 Innocents projects in Australia haven't really had that collective conversation, and no doubt that they will. And they're always going to be divided opinions. That any progress is great progress, but if there's going to be money diverted towards a criminal case review commission, I think a lot of that funding could be diverted to other mechanisms that would support post-conviction review, such as amending the current legislation.
And we've got more of a comment here, but there was a perspective that that this presentation reinforces the need for a CCRC. Some issues raised go to evidence law reform or procedural policy issues. Your position can be pursued whether or not there's a CCRC. What's your view on that?
Look, I think that's a very valid point. If you could be confident that appeal processes, that narrow criteria for appeal would be amended and more inclusive of other situations, other situations in which a conviction can be factually proven to have been wrong, at the same time as having a CCRC, I think that would be ideal.
Yeah.
But I wouldn't want to have a lot of resourcing necessarily. I think it's putting the chicken before the egg, or the other way around. It depends on which way you want to do it. I'd rather see that legislation in place and then look at what a CCRC can then do with that system in place, rather than impose a CCRC on an existing narrow structure, knowing that it's just going to force more cases through an extremely narrow funnel and potentially clog the system. And if it's a matter of having more applications, we'll appoint more judges.
Just another question that's come through. Hopefully I'm understanding it. There's a question on, can you explain why the unsafe safe threshold used by the English CCRC is a problem, given this is the legal test in the country? This test also captures innocent cases.
With the UK CCRC, I can't really comment on that test, because we're looking at what might be the situation in Australia, and the issue with the safe or unsafe, I need to pull it back to the threshold at which the threshold criteria for a CCRC, the CCRC reviewing the application in the first place and making a referral. So my point in that context is primarily about tying threshold criteria for a CCRC to known appeal criteria, because that will inherently limit how they look at a case and whether or not they will accept this particular case, regardless of whether or not they might actually uncover through their investigations evidence that might meet that appeal criteria. It just means that case just never gets a chance off the blocks.
I think this might be our last one. There's a question there. Thanks, Michelle. I also agree that we need more research looking at particularly vulnerable groups, including Australian Indigenous peoples. But to do this work, it needs to be Indigenous LED as a requirement at many universities now, and long-term partnership with Indigenous communities. Do you have any thoughts on best avenues to move forward with such work?
Unfortunately, I don't. I agree with you absolutely. And I think it's potentially, a lot of this is probably about getting the trust of, First Nations people, because, I mean, let's face it, there hasn't been a lot of success for them. There have been notable overturned convictions, but their experiences have been really poor. So I think we need to certainly show them that this process can be trusted, that they can engage with it, they can share information, and they can be comfortable in working towards a common goal.
Yep. I think that might be it in terms of questions, just in terms of time. What I will do though is I
am so sorry I went over.
That's right.
I was trying.
I'll post in the chat two things. So we've got our position paper. So if you want to have a look at that. And also there's a link there for our contact details. So if you want to ask any further questions from us, feel free to do so. There's an email there. There was also a question about slides and whether or not the slides would be made available somewhere. I don't know if Michelle.
Happy to. Very happy to. Yep.
Perfect. Well, thank you very much, Michelle, and thank you all for coming along. Oh, just so you know as well, the recording for this webinar will also be up on our new YouTube channel once I upload it, so you'll be able to share there. But thank you all for coming.
Thanks, everyone.